Hello and welcome again to DAO Day. This is, gosh, I've lost count now, but at least our third or fourth session are talking about the UK Law Commission's work on the digital assets consultation, which is proposing a third class of property. Iris Rad, our chair, has been preoccupied last week and this week, busy at work, lots of good things happening, and will rejoin us next week. So we'll get the benefit of handy summary slides, I understand, to commence again from next week. I think we charted, though, that we would focus today on chapters 12 and 13, but in looking at it, it probably makes sense to go through 11 as well as the basis to jump into the others. And chapter 11 is control. Chapter 12 goes to factual transfers of crypto tokens, that the ledger only represents the factual transfer and not the legal transfer. And chapter 13 expounds on that as to what will be indicative of a legal transfer of a crypto token. So at the outset, I'll just ask for any opening comments, impressions from those particular concepts or things that jumped out of you with those chapters, but otherwise we can get straight into the consultation questions.
I just love the fact that everyone's very curmudgeonly about the concept of possession and how lawyers have abstracted it, and this is very difficult. And rather than try and expand upon something that's so slippery, I think the words are like lumpy. Let's just go into something completely different and let's look at it from the prism of control. So I disagree with that. I think that makes sense. Yeah, why make something that's complex more complex? Yeah, just from a general perspective of how to look at it.
Sorry, just finding the mute button. The perpetual issue. Suze, you might be on the move, not in a position to talk, but feel free to speak up when you are.
Yeah, thank you. I just want to apologise for not having my camera on. I'm joining from my phone today, so I will jump in.
I'm waiting for you to have your own image that's your unknown. Nobody knows it's Susanna image.
Oh, right. So the two Japanese rabbits and small children doesn't really. Can you see that? I think I put that on about 10 years ago, and it's sort of still there, which is awkward. But anyway,
No, that's all good. All right. So I'm just going to jump in with the chapter 11 questions. It goes straight down to page 219 for those who are following at home. Question 16. The Law Commission provisionally proposes that the concept of control is more appropriate for data objects than the concept of possession. Do you agree? So I struggle with the concept of control with this, because in so many ways, and the later consultation questions they really go towards, should there be an expert working group formed to dynamically inform learnings around this application of the concept of control, and should there be should actually we leave it to the common law to continue to define control in these strange environments. And the discussions about the Law-Fi DAO membership token and having a social recovery process is really the hard work, the hard policy work that we're doing, because even though I may control a private key or a seed phrase at a particular time, unless I've gone to some third party independent body that's sort of a notary that says, yes, Joni Pirovich had control of this private key in full terms and in this seed phrase, or perhaps they just stop at the private key. If somebody steals my tokens or my wallet access is corrupted, and I no longer have it. So the state balance is not now referable to my wallet. What evidence do I draw upon to prove that I did have control and that I was the legal owner? And then who do I have rights against?
Joni, can I ask a question there though? Is there
Yeah.
benefit in drawing a distinction between possession in the legal sense and control? Because often in Web3 people conflate the two. So they say that because I have control, therefore I own it. But just because you steal it doesn't mean at law that you should possess it to the extent that you can possess it. So I see some value. I hear what you're saying from a practical perspective in terms of evidentiary, sort of establishing a claim, but having, you know, we do have this concept of I could have a car in my garage, but it may not be the car that I'm entitled to own. Well, so is there still merit from a legal analysis in having that distinction? I'm not necessarily saying one way or the other, but I'm interested in that, in the legal overlay there, because I do think in certain circumstances it may be beneficial, but there are definitely practical overlays. I can see Nathan wants to jump in.
Yeah, Nate.
No.
And Arturo, welcome, you've joined, so feel free to speak up if you're in a position to do so, or raise your hand and I can facilitate the discussion your way. I've always loved the statement.
I'm just eating while I'm doing this, so my camera's on.
It is lunchtime. But I'll butcher it, but possession is 9/10 of the law. So if you're the one that doesn't have possession, it's the uphill battle for you to prove that you should have possession, unless there's some legal register, typically, that has recorded that you are the rightful legal owner in the case of a vehicle, you know, whatever.
I get that, but is that the price you pay to actually have the benefit of being able to say the law can come to my defense if someone has stolen my digital asset? Sure, it might be difficult to prove, but at least there is some legal overlay that might give you restitution or some other, from a pure legal analysis perspective. I'm not saying it's easy, but
yeah.
May I
go ahead,
add something there? Two things. So first of all, I hear almost all reference to, let's say, control directly linked to the concept of a private key, which I think could be detrimental, because as technology progresses, private keys were not necessarily the way in which you have control over a digital asset. You know, let me just put that aside. Second of all, if you have control of the digital assets, and Susan, I agree with you in terms of making the separation between ownership and control, but maybe it shouldn't be ownership and control. Maybe it is legal liability and control. The reason I make that distinction is because, let's say that I have control over a specific wallet that is used in Tornado Cash and people go against me. Maybe the wallet is empty, has no tokens, but I do something that I'm not supposed to be doing. I think that the biggest risk that I carry there is that me as an individual get attacked for being seen as the person that is actually doing things that are illegal. Because, you know, the ownership element, again, then maybe we'd have to go back, which I think that we still need to do, and really define what ownership actually means within this context. But the legal liability of action on the basis of identity being seen as the owner of the private key is where it doesn't matter how much you discuss it. If you're going to get screwed, you're going to get screwed, right?
Well, this is actually later on in the further chapters, they go about needing to recognize new causes of action and new legal remedies for the new sorts of things that will be possible with this technology, which is sort of your Tornado Cash example. So if you look at it from the perspective of, no, it wasn't me in control of private key or replace relevant word at the time, therefore I am not liable for whatever actions were associated with it. Again, like do I have to go to some sort of independent third party if there's no legal recognized registry to prove that it wasn't me at that time? No, yeah, sorry, Nathan, did you have something on that? Just nodding vehemently. Yeah, I don't know if that's helping, Susanna, but I'm racking my brain to think of another concept of possession that brings the stark contrast into light as to why focusing on control would be better than possession, in just at least demonstrating from the perspective of the person. If I've lost tokens or lost access to a wallet or have suffered an attack,
so
why control might be a better concept from that perspective. And Arturo brings in the reverse perspective of an attack, an attack against me.
Yeah, which is a really interesting perspective as well, and something I need to think a bit more about. But the law already deals with circumstances where evidence is difficult. So we have statutory declarations, we have affidavits, we have a mechanism under oath to give. Now that's all, you know, test evidence. It's not always bulletproof, but I'm yet to be convinced that just because it's hard doesn't mean the way the law has always thought about some of these concepts automatically shouldn't apply. I need to be convinced a little bit more, maybe on the practical side there.
Well, it'll feel like a tangent, but I don't think it is. If we actually start having wallets that are our digital identities, and we assume we get to a system of self-sovereign identity, or at least CBDCs, where the wallet supports that that's my identity, I think that when we interact or sign a transaction to send Bitcoin or interact with a lending protocol, that process of a statutory declaration or an affidavit, it could be introduced in a more real-time basis as shorthand would be a digital certificate of sorts, or otherwise, if it goes back to your identity, a presentation or a verifiable credential can be issued at the time to say, yes, I, Joni Pirovich, affirm or swear that this is me making the transaction, which has to then be supported by some sort of multi-factor authentication or proof of personhood at the time, which introduces more friction at the time, but at least gets you that better evidentiary basis. And my experience at the moment with token stuff in litigation and sort of a person's recollection being put into affidavits without further supporting circumstantial evidence and independent third-party evidence, our fear is actually that it won't be as heavily weighted evidence in deciding the matter, which individuals shouldn't be put to that standard. It just feels wrong to me.
It's an interesting one, isn't it?
Yeah, but that's all the stuff that I think we're going to test through our membership token design and the social recovery, and really because unless you have digital identity at the wallet level, I don't think you can ever get to a point of establishing after the fact that it was you
or not,
or that you controlled.
Yeah, or not, because you've got to do this in the alternative, right, don't you? Because that's, in some cases, that's actually, because I was also thinking of the idea of if you needed to prove evidentially that you had lost your seed phrase or your private key, how do you actually evidence that, or what kind of, you know, could a stat deck, could some form of evidence be sensible? Obviously, if, you know, if your house is robbed and you've lost some hardware, well, you can put a police report in, but there's still no evidence you've actually lost it. It's fraught with danger.
May I ask? You use the word lost. These are
lost from your control, I mean, or your person.
How about if it's copied?
Well,
that
then you've
make a
lost exclusive
difference?
control. Yeah, I think,
Correct,
well,
yeah.
it's the same thing because somebody else then has, yeah, if it's copied, somebody else can then control. And I think this is where the concept of control in the traditional legal sense comes in. You no longer have exclusive possession. That's why property is really important, because the concept of property at law is generally that you have something at the exclusion of all others. And that's why we can wrap a whole bunch of legal rights and obligations around property.
It also comes to the point of rivalrousness of
Yes.
the data record as well. Once you copy it ad infinitum, it loses that quality of rivalrousness, which is also interesting because therefore does it lose the what happens when something is copied? Does it change the quality of it?
From a technology perspective, copying the private key just creates, let's call it, fungible versions of your identity. You can't distinguish between them, right? And within the blockchain context, that's not supposed to have, like, that's a scenario that the technology doesn't really cover. It assumes that the private key is uniquely held by one individual.
I know, Nathan, I don't know if you're in a position to talk about this, but just we'll go to the next question if you're not. The Fireblocks solution, which it's an approach to managing private keys where I suppose one would suggest that exclusive control is maintained by the individual, even though it's sort of a permission-based system to be able to send or sign transactions. Let me know if you can't talk to it. Or
is this in regards to MPC?
Yeah.
Yeah, so it's an interesting one because it's quite similar to multi-sig wallets, I guess, but it's a bit more efficient, a bit more cheap. So beyond those factors, it's the same. Like when we want to send money out of Fireblocks, we have to have at least one person or two people putting forth their fragmentation of the private key. So to some extent, a little bit, you could sort of you could contend that it's a bit like Community because you have to be verified by people you know. But the interesting thing here is once you've had people you know saying yes, then the actual key fragments are then put together by other nodes. So for example, let's say I'm trying to send money out of Fireblocks for work, and I'm going to get somebody else to say yes as part of the multi-sig side. Then once they've said yes, different nodes in Fireblocks will come together, put these different fragments together in one step, and then verify me or verify my transaction as my private key. So it's a weird way to be custodial or non-custodial here. A bit of both because we have control, but we're actually holding it, which is a bad thing. So we own the private key, but we don't really get to see it because Fireblocks owns it in different chunks. So even they don't see it. So it's really a no custodial or a broken up custodial solution where it's almost like Community because someone in the community that you know has to say yes, and then it's sent by different groups, I guess. If that makes sense.
It's that social recovery, but also I've never copied my full private key or insert other relevant word.
Yeah.
I still hold the full one if I have my own record of it.
Yep.
But in order to maybe enhance safety and procedures around when my tokens, if I can call it that, can be moved, then it's just extra layers of security. But without that third party affidavit at the time.
Exactly. Yeah.
Nathan, do you think that it would be fair to describe that as almost, if we assume that identity is defined by private key, identity in this case gets two layers. It's the identity of the individual plus the social identity of a group of individuals that basically upon signature need to verify that, or need to be add their little salt into the mix so that the final identity is verified. Yeah,
exactly. That's why it's a different debate, but to say that my private key makes my identity it's almost debatable because what if I want to have different identities, right? What if I want to have different identities as part of my one wallet? In which case, I've got to have like a different, like a segmentations for maybe a pseudonym online, and maybe the real me or my work version. Assuming that most transactions and most community building happens on chain, then I'm going to need to have multiple identities. So to say that one private key equals one identity is probably won't actually be implemented that way. It'll be more like a new token standard, I guess, which can house your identity. So sort of, it sounds interesting, but it's like a token inception where you have one token to house different tokens, and that new token will be your identity.
I think that the issue here is not really a technological one in terms of how we define identity within the blockchain, because as soon as we do so, like we have the ability to define identity however we want to. Is it a commingled identity? Whatever it is. I think the question mark is, how do you actually make that compatible with the Web 2 versions, let's call it the legal versions of what identity are, which are very, very different to what the potential is in Web 3, right?
Yeah.
Well, I'm going to keep us moving because we've got a few questions still to go. The next one is that the Law Commission provisionally proposes that, broadly speaking, a person in control of a data object at a particular moment in time should be taken to be the person who is able sufficiently to exclude others from the data object. Number two, to put the data object to uses of which it is capable, including, if applicable, to effect a passing off or transfer of that control to another person or a divestiture of control. And three, to identify themselves as the person with the abilities specified in 1 to 2 above. Do you agree? So it kind of, we may have answered it already, but it's that affidavit at the time or the social recovery process or the verification process.
I think that even without those edge scenarios, maybe it's clear, but I wonder, how does the custodial wallet scenario work in that case? Because the custodian has the ability to execute trades on behalf of the other.
Well, not if the custodian is using something like Fireblocks, because the custodian never has the unilateral ability to send something without the customer being on the multi-sig.
Not quite, Jenny.
Not quite.
So-
Forgive me.
Wouldn't there be
So-
other custodial arrangements where the custodian could have some kind of delegated control?
Yeah. Sorry,
Yes,
Nathan. Correct me if I've said that wrong.
No. So there are ones where it requires the client, but the customer. But for a firm or a fund like ZeroCap, for example, we can't say, all right, we're going to make a trade because someone asked us to do it, and then put it through, and then wait, because think about the slippage, right? The price will be completely different. We're going to be losing money, and the trade won't be what they wanted. So that can't happen. So instead, Fireblocks completely delegates power. The client or customer delegates power to us. So on Fireblocks, all we have to do, let's say I'm a trader, I'm going to say, I want to make this transaction, right? And I ask Fireblocks, and what happens first is we have to get somebody else to sign off on it. And as soon as that's happened, then it's finished. It goes. Obviously we did that on the client's request, but that means it has to be trust. So with Fireblocks, it doesn't remove it. Like they delegate, because unless the thing about Fireblocks is, unless I, as an individual, not as someone working at ZeroCap, have the means to pay for Fireblocks, my own workspace, which I don't, unfortunately, because it's very expensive at the moment, then you lose control. So you're sacrificing, similar to most custodial solutions, you're sacrificing the fact that you're no longer on your tokens because you want to have better security. And that's the most common trade-off that we're seeing at the moment, I think.
Yeah, well, and I think I referred to, what I meant is the pure custody and the insured custody arrangements where there's no active trading, but basically I still have the control to say I sign for a withdrawal or, for further things to be sent to it from a custody account to the insured custody account, basically.
Yeah. From that step, yeah, 100%. We can't just take your money. Yeah, exactly. Yeah.
Yeah.
What about commingled assets held in group wallet?
This, I think, really needs to be looked at under the hood, because I suspect that more exchanges, centralized exchanges, are doing that than customers believe, and they're relying on the segregation with a sort of Excel database, which if the whole commingled account represents the customer deposits and it's not used for any other proprietary trading of the centralized exchange, perhaps the segregation in a separate database is okay. And it's perhaps more efficient because you don't have a lot of network fees back and forth with all separate instances of wallets. But it's common practice, that commingling, and there's no real standard, at least none that I'm aware of, that requires a digital currency exchange registered with AUSTRAC or the proposals with VASPs, but that's a money laundering and terrorism financing perspective. None of it requires a disclosure on the method yet.
Because the fact that the method exists proves, I think, is the first or the second lens. So it's a requirement. So being able to put data objects to the users to which they're capable and affect harnessing or the transfer of control to another person. So I think it's just complicated when we start looking at commingling arrangements and there's no.
But if you have deposited your tokens with a centralized exchange, a new thing in action has been created because they've got terms and conditions on their website. Whether they tell you exactly what's going on or not is a different thing, but they will say either if you apply to withdraw your tokens, it will take us 1 to 2 days and subject to these withdrawal limits. And if they don't follow that, then you do have a thing in action, a cause in action against the legal person that is the exchange. So I think it's more about the legal questions when you're in that parallel universe of the borderless Web3 rather than with the centralized entities.
I think that the question of commingling in this case, although in its nature is a bit convoluted, you still have a proper definition of identity of the different of the entities that are involved within the commingling process. And at least from my point of view, the question mark that I have with regards to the statement was that I perceived the definition of identity through the control of the private key, which is it's kind of like that's the action that lives outside of the clearly defined boundaries and physics, let's put it that way, of the blockchain, and that I believe that legislation is trying to identify and describe and understand, but because it's kind of like an edge, it's not even an edge case, it's an outside case of blockchain, then doing so incorrectly could have very, very weird secondary effects that just need to be thought through carefully. And commingling is not one of those. Like, commingling is either on chain and identity is very clear, or it's off chain, and again identity is also very clear, right? It's really that definition of who is who.
Spirit of doing that quickly. The next one is that the Law Commission provisionally concludes the concept of control as it applies to data objects should be developed through the common law rather than being codified and clarified in statute. Do you agree? My opening comment would be the technology is moving so quickly that to wait a couple of years for something to be decided in the courts it doesn't give the market certainty when it's needed.
And also, how are you going to educate judges on the complexity of this space within the confines of the trial, within the confines of the list and dockets that are full, and for things to be given the proper attention that they need to be given to be able to be understood before you can even pass a judgment on it? I just don't think it's practical.
Yeah, I think it's a dangerous assumption to say that the parties in a trial will authentically put forth all the information relevant for a judge to make a decision and create that common law, rather than having committees or recommendations from us and many other entities putting it forth as it should be, should be actually considered. Right, like
That's-
in a scientific method, pretty much, yeah.
That's the next question. So that they also conclude that it would be beneficial for a panel of industry, legal and technical experts to provide non-binding guidance on the complex and evolving issues relating to control and other issues involving data objects more broadly. Do you agree? So if that pans out in the same way that the UK, they did this legal statement around smart contracts and smart legal contracts, and it's sort of, even though it's non-binding, in judgments, it has been referred to as if it's the closest thing to precedential value, and it's got that high integrity because it was written by a judge.
Yeah, and it's almost like it's a playbook for a judge who comes up against this sort of issue. They do have incredibly high standing.
What are some examples of industry like corpuses to provide that type of evidence? I just can't think of any that come to mind.
Well, sometimes they create expert reference groups just around a particular topic. So you'd have someone like Sarah Green from the Commission, the Law Commission. They've got a lot of people with a lot of contacts. I think they'd go fairly far and wide and just get the best group of people that they could identify for the job, because they take this very, very seriously.
Yeah, you can tell in the quality of the document. It's very well done.
May I ask, and I need to jump off to a call in a few minutes, and hopefully I can come back, but isn't the question here, like, do you actually need to have new legal frameworks for this context? Or can you live off the old legal frameworks where the discretion effectively is, and how do you map the let's call it the digital object with the legal object? And I think that's the only time it's the only way in which you can do this practically, where every case experts come in and say, well, this object maps to this legal identity because X, Y, and Z reason, and therefore you should apply the existing legal infrastructure to make a decision of what's wrong or right. Because if you actually start going down the route of writing new legislation, then it's almost like you have to tear everything up and start writing it from the ground up, I think. But again, I'm not a lawyer. I'll be back in a few minutes.
We welcome that. No, thanks, Arturo.
You feel very damned if you do. I'm sorry.
Arturo raises a good point, which is to codify, to have a comprehensive statute that deals with every situation will be very, very difficult, and that's why the law has always been about first principles, and why that is really, really important to see what parts of existing law and legal principles can we draw parallels with in terms of data objects and digital assets, and then where does the technology make it that so different in terms of the way that the practical application of these things where those concepts don't apply. And Joni, you raised a couple of them earlier, but I think that's going to be the trick, is for industry to be able to very articulately and clearly explain why some of those concepts may not work in certain circumstances and what would be a practical solution. And I can't do that because I'm not, but yeah.
Well, it's a multidisciplinary exercise, and that's what the question says. No lawyer can do it on their own. But I think it just goes to show we haven't really written digital identity legislation properly yet, nor has, I know that there's exposure draft legislation in Australia, which Suze, you and I commented on, but
yeah, we're a long way from what you're talking about, and we're not going to get there in the time that we need to get a solution for this.
Well, and law is supposed to be the codification of social norms, and if we're still experimenting and we haven't found our norms, it just feels wrong to codify it, and so therefore it should develop through the common law. But there should be some sort of dynamic guidance in the interim.
Well, I think the only way the common law will be able to apply is if we can map common law principles and general legal principles to these things. And then, you know, let's say hypothetically, there is a third class of personal property and it's suddenly you've got property rights and there are other practical applications. Then the courts can work out the edge cases and they'll work through it eventually because they can use the framework of those principles. And I think in some ways, shoehorning digital assets into a concept of property does give, maybe it's not the best outcome, but at least it gives a pathway to an outcome.
Yeah, I think we could go around in circles for days on this one. All right, so next question. The Law Commission, this is now in chapter 12, so the factual concept of control. The Law Commission provisionally concludes that a transfer operation that affects a state change within a crypto token system will typically involve the replacing, modifying, destroying, cancelling or eliminating of a pre-transfer crypto token and the resulting corresponding causal creation of a new modified or causally related crypto token. Do you agree? And I think the next question is related, so we can deal with them together. That this analysis applies, forgive the background noise, apologies, in respect of UTXO, so that's the unspent transaction-based, account-based and token standard-based, both fungible and non-fungible crypto token implementations. So my big comment here is that looking at each token transaction recorded to the ledger doesn't reflect the bundle of rights or the full arrangement of what a person is entering into. So it's wrong to look at just one transfer operation as the factual state change. It's too narrow of a factual inquiry, and that's my only concern, I think, here.
Can you explain that to me, Joni?
So when you're interacting with protocols and as they get more complex, it might feel like it's just one transaction that you're signing through the website front end, and when you're in MetaMask or your other wallet, it says confirm, and sometimes it says you'll have to make multiple confirmations. When your transaction is recorded, the information might not necessarily reveal to you that that's been 6 blockchain transactions or ledger transactions, which has affected the state change of many wallets, including yours. So to just look at one, for me, it's and especially if they're including non-fungible crypto token implementations, those are the ones that are throwing up a lot of the transactions.
Yeah, okay, that
doesn't make sense.
And so, yeah, but does it? So I hear what you're saying about the number, but even on the granular level of detail, I can't remember the wording of the question. Let's say it was a 1-for-1 transfer. Let's just hypothetically assume it's a 1-for-1. Is it the case technically, technologically and practically that question is correct for a 1-to-1 transfer?
And it only deals with the base case.
Yeah, okay. So the point is that if you're not doing you may need to transact with multiple wallets to achieve the outcome that you're trying to do in your one transaction. Yeah.
Yeah, and I think a different concern that's really important. Like the idea of a steady state in crypto or like a replicated state is very rarely true, because there's always things changing. Even if you're looking at transactions that are waiting to go through, right? There are always more going through, and then like maybe that'll be picked first, maybe they won't be picked first, but that ends up being a different concern about like parallel computing. So there's quite a few new protocols coming out, blockchains coming out, like I'm going to pronounce it wrong, but SU, Aptos and Fuel, and there's so many that are coming out now that want to have parallel computing for blockchain, which is a really interesting idea because, like, for example, if you're looking at Uniswap, the way it works is every time someone deposits money or makes a trade, which is depositing and pulling stuff out of the AMM pool or the LP pool, the orders rebalance, the price rebalances, right? So if you were to have different transactions going through at different points, how do you know what to charge everybody? So the state will never actually be the same. It'll always be changing because there'll always be different transactions being pushed off the different parallels onto the main chain. So it's complicated.
Probably a weird question, because from a non-technical perspective, from a non-legal perspective, from what I understand, the question is for that one specific person or case where you're looking at the transaction, even if there are other multiple transactions which get impacted, how would it impact what the court is looking at or what the law is looking at for that specific transaction? If I do something on Uniswap, I think wouldn't the question pretty much ask what is the impact of me doing that transaction for my scenario and not all the other 10 scenarios that are happening because of the transaction? They would be looked at in 10 different other cases.
Yeah, the simple example is if you just look at the one transaction of the ETH going out of my wallet, and that's either a transfer or a cancellation, then that's a tax event, a tax disposal event. And so if I don't then look at all of the other wallet and state balance changes and the full nature of the arrangement, the fact saying that one transaction is the correct factual reference is not correct. It's got to be the factual arrangement.
In your case, isn't that so when you say the entire arrangement, is that the entire arrangement for your transaction or what happens on the Ether blockchain, on the Ethereum blockchain?
Well, what happens if it's from my perspective, what happens to my property rights? The trigger when I send my ETH and it gets turned into WETH, the gem join contract in the MakerDAO protocol, it updates its mapping. It doesn't actually send another transaction to record specifically that the DAI minted and going back to me is a transaction that affects the state. It's only linked back by the mapping. So the state change is not, I think that's the point. The state change is not the full story. You actually have to look at the mapping in the smart contract and how it connects the state changes. Yeah, but at least that's relevant from a tax analysis, which relies on what is the property and what is the bundle of rights.
And then a different way of thinking about it. You mentioned it already, Joni, but it's one transaction is not one transaction, right? Because especially on DeFi, like if you ever look at a transaction of a bridge from blockchain to blockchain, or even using any DEX, there's like so many things happening at the same time, right? So there's swap, and then you end up with what you wanted, right? It's never going to be like, all right, I'm going to a pool and I'm putting in ETH and I'm getting out DAI, or I'm getting out whatever it happens to be. It's always like I'm swapping with 5 different people. It's routing through the best and most efficient way, depending on volumes and depending on slippage and depending on speed and depending on the blockchain. And then there's heaps of factors that go into it to make it optimal, which is what all protocols are trying to do. So everyone's using it.
Let's make it a little bit more complicated. Layer 2s is that's exactly what they do. So I guess it depends on where you define a transaction has actually occurred.
And then even if on more to that, even if we start thinking about the blockchain as only layer 1 and then the layer 2s being on top of that being like side chains, I guess that doesn't actually become its whole new blockchain. So then does the constant changes from transactions being compressed and pushed through layer 2s onto layer 1s change the state? It's a different way of thinking about it.
It draws out the key questions we need to ask, because as my basic understanding, there's the zero knowledge roll-ups and then the optimistic roll-ups, and one is more reliable than the other, but the other is faster than the other. and so from a legal perspective, where layer 1 has to use a layer 2, will the law prefer basically the ZK roll-up? Arturo and Nathan, correct me if I'm getting this wrong, but the law could tend towards preferring one and then distort the market innovation to that one rather than, the more efficient market solution.
Yeah,
Did I get
think
that
that's sort
right,
of,
Nathan? I've probably
yeah. I mean, no, it's right, and Arturo knows much more about this than I do. But I think, regardless of what happens with the law, because of where innovation is in regards to optimistic and ZK as rollups, there's no way that optimistic rollups won't be used for the next little while until we can have some sort of EVM compatible ZK proof or network, like what ZK Sync and whatever Polygon Hermes are trying to do, which is not very easy until. Or maybe even until Ethereum is until some base layer changes have been made to allow for rollups, ZK to be pushed onto chain more efficiently and more effectively. Innovation law won't really change the adoption, much of the adoption, because of like what's required and what's being used.
I think that in general, for the law to try to describe technology to the point where it even has a reference to optimistic versus ZK rollups would just be a dead end really quickly. It's almost like legal description happens or stops happening as soon as it becomes on-chain. And then it starts existing again once you kind of, it's the on-ramp, off-ramp conversation, right? It's almost like it's a bridge between legal land and decentral land.
Just put me in a dark room with a towel around my head because it's breaking my brain. It really does. Pushes your mind to the limits. All right, so moving through to question 21, this goes to the Law Commission provisionally concludes that the rules of derivative transfer of title apply to crypto tokens, notwithstanding that a transfer of a crypto token by a transfer operation that affects a state change involves the creation of a new causally related thing. So I'll just have to pause to understand that question as well. It's a very wordy one.
Jeremy, could you possibly put like copy and paste that onto the chat so I can also like for me I'll find it much easier to like reread it. Thanks.
I know. Bear with me while I do that. Oh, you've done it already. Great, Vic. Yeah, so derivative transfers of title, though, just to explain that concept, is that nothing new is created when I transfer my Bitcoin to you, Arturo, or in respect of other property rights. That it's really a transfer of existing rights, and so that's where I don't create a new legal title afresh. I'm just sharing or passing on the existing legal rights in relation to that thing. Now, the paper doesn't deal with this, but since the paper's release, we've had the Can't Be Evil licensing suite. And one of the assumptions in those license is that on transfer of a token, all existing sort of arrangements are treated as terminated. So if when you've had your NFT and it's linked to whatever image, you sub-licensed it to this restaurant, sub-licensed it to Tiffany's, the jeweler, and those separate arrangements were like, one was for 3 years, one was for 5 years, but hey, it just turns out circumstances are such that you want to sell the token, then all of those existing rights terminate. And so this is attempted to be a standard position in the market so that it results in less legal issues and claims, and purchasers can rely on the fact that when they buy the NFT or whatever it is, they buy it free of any of encumbrances from the previous owner or owners or arrangements that they entered into. So if CBE licenses are adopted as the standard, then we don't so much need to bring in a lot of the things that go wrong with derivative transfers of, like, so the historic or the baggage that's associated with something when it's passed on. So the further questions go to whether there's a special defence of a good faith purchaser. And again, I don't think that that's necessary if this licensing standard is adopted, but it's unclear how that standard would apply to fungible tokens. And the rights in relation to a fungible token, particularly when it's labelled as a governance token, that's really its own maze. So the proposed rules by the Law Commission maybe do make sense in that context. Is this getting too legalese now? It's a tough one. Yeah, I think that the role of standardization will be key, because as we said, the common law will develop too slow to apply those other concepts to our experiences with tokens. But to the extent that you can strongly rely that there's functional equivalence and then therefore regulatory equivalence, you may have a stronger case to rely on those concepts and not need to bring a matter to court, because your lawyers can write good letters and rely on strong enough case law, like salient enough, transferable enough case law principles. Apologies again for the background noise. Go ahead, Arturo.
Yeah, the only comment I would have here is that, very much unlike me, there are a few things that I like with regards to this statement. And the one that I like the most is a reference to, I think, one of the most general descriptions of a blockchain, which is the state change. I think that state changes will be part of blockchain systems for a very, very long time. I can't see how blockchains cannot exist without state changes. Now, why that is important is because state changes, it's almost like we're trying to do a reverse oracle from what happens on chain to legal land, right? And as if you're writing a derivative contract in traditional space, the first thing you need to have is an event, right? It's an index, and it's a change to that index. And you want that describability to be as generic as possible so that you can cover as many scenarios as possible. Therefore, acknowledging the state change as the event that defines a change in whatever it is that you're trying to describe makes a lot of sense. And if we leave it at that, and then upon every single case, look at the actual detail of the smart contract in question, that could actually work.
Yeah, and I think this is just dealing with that base case of I transfer it to you.
Yeah, no, I agree.
Yeah, but the other thing is, this could be enormously helpful to clarify in the context of governance tokens, because if I am the holder of the governance token and I've made representations, I've made promises, people have relied on those promises to invest in the governance token, but then I sell the governance token to Vic, the wiping out of the history of the representations I've made is a clean legal position for Vic, especially if a DAO is a partnership, and if I've had any sort of authority to bind the partnership to those representations. There may be a case, even though it's a continuing reconstituted partnership, so I'm no longer in it, but Vic is, that perhaps she doesn't have liability because she only entered after the time that I left. And those associations were only resulting in liability to the partnership as it was constituted up until I left. And so normally in a partnership, you'd have this deed of exit or some legal document that says you will continue to remain liable, and therefore you've got to keep your professional indemnity insurance for X number of years after, if there are any claims that are really attributable to your behaviour. So the partnership might face initial liability, but they may then seek to sue the particular individuals involved, so that the partnership is not out of pocket. And so in the governance token context, I think it's a rough example, but it could actually be helpful. Okay, we're nearly there. Last question. The special defence, we provisionally propose that a special defence of the good faith purchaser for value without notice should apply to the transfer of a crypto token by a transfer operation that affects the state change. Do you agree? I think we do. The innocent acquisition rule should apply to both fungible and non-fungible technical implementations of crypto tokens. Yeah, I don't think there's a basis to distinguish whether it's one or the other. It's the representations that matter, or the arrangements. And the innocent acquisition rule cannot and should not apply automatically to things that are linked to the crypto token. So this is perhaps if there's real property that has been tokenized, or there's IP ownership of the artwork that's linked to an NFT, it means that just because you've purchased an NFT, if you haven't gone and looked at if there's terms and conditions, if the IP owner, if the artist never actually gave permission for that artwork to be used in those NFTs, then the fact that you didn't make your inquiries is not a good defense. So I think that's correct. I've stunned you all into silence, or it's hurt our brains too much. So I might close it at that point, unless you have further comments.
More of a question.
Yeah.
And the question is that to a certain degree, I don't really understand even why the conversation is held this way. The reason is because if I write, if I were to draw a picture or source a picture, look, let me put it this way. If I were to create an NFT outside of the blockchain and I did it on paper, right? Or if I did exactly the same thing, but I put it on a piece of glass, there'd be a difference that it's on a paper versus that it's on a piece of glass, as in the contract, the liability that is expressed, or that is that is part of the action of me giving away this piece of paper or this piece of glass. I would assume not, because the medium is irrelevant. In this case, blockchain is just another medium. And it seems to me like what we're trying to do is see the medium as, look, it is either a separate legal framework or it's just a medium. It can't be kind of both at the same time.
And that's exactly what they're trying to draw out, lots of examples and questions to understand whether there's any line in the sand or clear boundary between when we're dealing with pure information, source code, versus legal rights. So we will continue to keep going around in circles for at least another few weeks on that one. But thank you for all of your contributions today. I love these discussions and glad to be going through them with you. Next week, if you do want to do any pre-reading, we'll focus on chapters 13 and 14. And hopefully we'll have Iris back to help us with some slides. So enjoy and see you soon.
Thanks, bye.
Bye.
Bye.